She has a Juris Doctor from Harvard Law School, a master's in public policy from the Kennedy School of Government, and a bachelor's from the University of Wyoming. She's a 22-year Wall Street veteran who's been active in Bitcoin and blockchain since 2012. Yeah, that's right, OG.
No.
Yeah. She's been leading the charge to make her native state of Wyoming an oasis for blockchain companies ever since. She's helped to enact 14 blockchain-enabling laws in 2018 and 2019 in Wyoming. Was that a clap? Yeah, that's right. Thank you. And from 2016 to 2018, she jointly spearheaded a blockchain project for delivering market index data to Vanguard as chairman and president of Symbiont. It is my great, great, great pleasure to welcome today Caitlin Long.
Thank you, Pamela. Thank you. Thank you, everybody. It is my honor to be here. I am thrilled to participate in an event that has such an education focus. And I understand that there may be continuing legal education credit for the attorneys in the room, so we have to go exactly 50 minutes, in a minimum of 50 minutes in order to get CLE credit. So I'm gonna dive right in. Let's please make this interactive. I am a Wyoming native, and I kind of knew pretty early on that the ethos of Wyoming and the ethos of this industry have a lot of overlap. Wyoming is a state that believes in rugged individualism. It is a state that tends to buck the system. And in fact, actually, my alma mater's motto is bucking the system since 1886. And it is a state that actively embraces privacy. In fact, actually, there were some folks in Wyoming who were embarrassed that Wyoming LLCs, by the way, the limited liability company form was invented in Wyoming in 1977. And there were some folks who were embarrassed that Wyoming LLCs showed up all over the Panama Papers. And so the legislature considered whether the state should start collecting information about the owners of Wyoming LLCs. And in fact, the legislature voted it down overwhelmingly because they respect privacy. So there's so much about the ethos of Wyoming that actually fits with the ethos of this industry. I think a lot of folks early on were sort of scratching their heads saying, why Wyoming, right? It's in the middle of nowhere. It's not a state that is known for financial services. It's not like South Dakota, which is its next door neighbor, that has the credit card industry, right? So there wasn't anything that was obvious to folks who didn't know what was really going on. But in fact, it's really obvious. And just 2 weeks ago, the governor of Wyoming signed a proclamation that he wants to make Wyoming the cryptocurrency capital of the United States. He actually used those words. So it's a real movement. And what I'd like to talk to you today about is, let me make sure I understand how this clicker works. There we go. Oop, there we go. The impact of that and the meaning of this for you. I'm a volunteer. I'm a trained attorney, but I'm not actually licensed to practice in Wyoming. None of this is legal advice. And I have been, when folks contact me, directing you to folks who actually can help you. We're starting to get some pretty sophisticated attorneys in Wyoming on these legal issues for your business. But I'll give you the questions that you need to talk about. Let's start with this whole code is law versus backwards compatibility of code with the law. I think a lot of developers, I took a lot of heat actually from developers in the Twitter sphere early on about why Wyoming, why would we bother to create enabling laws? Because code is law and we don't need to pay attention to the law. And I am sympathetic with that view, but I also recognize the reality that none of us live in a legal system without laws, right? Unless you're living on a seastead, you are living in a place that actually has existing laws. And so how do we take new technology and make sure that it doesn't conflict with the law? We make it backwards compatible with the law, to use Trace Mayer's phrase. I like that phrase because that's exactly what Wyoming has done. These laws that we've passed have put a lot of words on the books, but what they are is actually giving, every single one of them is an enabling law, with one exception, which is a new type of financial institution I'll talk about in a minute. But what they do is also give the lawyers in the room the ability to give legal opinions because they actually spell out specific things that enable this technology to exist. I think Wyoming already is the Delaware of digital asset law. For those who are not familiar, Delaware is where most companies incorporate. Most companies are domiciled there, and most LLCs. So between corporations and limited liability companies, Delaware has always dominated, and there are a few reasons for that. Delaware has Of course, a very extensive body of case law because of its leadership in this area, which is more than a century old. But it also has a very specialized court where business disputes can be litigated, and a lot of attorneys will make recommendations to you, businesses, to put your business there just because it's where everybody goes. And in fact, actually, I've heard some rumblings that the venture capital world still wants Delaware holding companies for startups in this industry, even if your operating business is in Wyoming. I'm going to encourage you to challenge that, because Wyoming just created a chancery court, a court for specialized business disputes, along with all the other body of law that we created. We're making a real run at Delaware. We are already number 2 for business entity organizations, as I mentioned in the middle of the slide. It goes Delaware, and then Wyoming, then Nevada, and then a big drop-off to the other big states like California and Texas. But you want to organize your business in one of those top few states, and Delaware's going to hit you with a bunch of taxes that Wyoming and Nevada, actually Nevada has a gross receipts tax, so Nevada's going to hit you with taxes too. Really, Wyoming does stand out. And in this industry, I'm going to convince you, I hope, that the legal certainty that you're going to get is worth the trade-off of the fact that Wyoming is newer than Delaware in this whole chancery court issue. There are 3 ways to benefit here. Wyoming has a choice of law for your contracts. You don't have to be a Wyoming domiciled entity to have your terms of service and other related contracts governed by Wyoming law, and I think you're going to want to do that. The second one is domicile your company in Wyoming. There are a few thousand companies probably by now that already have done that. And again, we don't have great statistics because Wyoming doesn't collect that information. They don't have that information to share with the IRS. And then also locate in Wyoming. You're going to, I think, by September, start to hear some announcements of some pretty significant companies that if they get licenses for these new special purpose depository institutions, the applications for which open October 1st, if they get those licenses, they'll be in Wyoming by this time next year. And so I think there's a coattail effect that's going to come pretty fast and furious. Wyoming is a state, we want to be known as the state where digital asset investor rights are protected. Obviously, I'm a big proof of keys person, but I also recognize that big institutional investors by law have to custody their assets with third parties, and therefore digital asset custodians in Wyoming have to be solvent. Many of you know I'm actually a pretty big critic of the traditional financial industry, not so much the people. There are certainly some nefarious people, but the market structure, it's a bad system design. We wouldn't design the financial system the same way if we were creating it from scratch today. It would look a lot more like what these decentralized technologies that we're all here to talk about today would enable. We wouldn't create these centralized power structures. We wouldn't have captured regulators that enable things that we all kind of in our gut know are illegal. I'll give you an example, a very recent example, the Uber IPO. The Uber IPO, a lot of folks lost money on that. And it came out that the underwriters did something called naked shorting. Now, what is naked shorting? Naked shorting is selling an asset you don't own, selling more securities than actually existed. The way underwriters work, and I worked on Wall Street a long time, worked on IPOs actually as well. If you're going to sell 1 million shares, the underwriters get what's called a green shoe, an over-allotment option, which is legally, validly issued shares that they can sell into the market to stabilize the price. But in the Uber IPO, not only did they have the ability to issue more shares through the green shoe, which everybody knows about, but they, unbeknownst to everybody, had the ability to sell more shares that were not validly issued. What do you think that did to the price? It suppressed the price, right? And so I went digging when all that happened and said, how on earth was this legal, right? It's one of those things that hits you in the gut. How can it be legal for somebody to sell something they don't own that doesn't even exist, that's not validly issued? And it turns out it was legal. The SEC allowed them to do it. So the good news about the state of Wyoming, and by the way, that's just one of many examples. I saw heads shaking in the room. That's just one of many examples that I can point to about why the existing financial system is unfair to regular folks. It also is unstable to regular folks or to everybody. And Wyoming is going to be creating the industry that will be investor friendly. It will be the place where investor rights are protected and the place where all the financial institutions that come in from this new industry are solvent. I'm not going to read all these slides. These are available to you on SCED. They just describe the bills that we passed, but I'll highlight a couple of things. The last one, there's no income tax in Wyoming, and we also passed in 2018 a law that clarifies that there's also no property tax on digital currencies. So what that means is that basically your crypto is just not going to be taxed at the state level in Wyoming. The other bill that I think is probably the most important one from 2018 is the second one on the page, House Bill 70, which defined utility tokens and exempted them from state securities laws. Now, the way securities laws work in the United States is that the feds have supremacy over the states. So you may think, well, what impact did that really have if we're trying to say that certain tokens in this industry are not securities under state law? The SEC trumps the states, so what does that matter? And the answer is, the way the legal regime works in this country is that property law is defined by the states, securities law is defined by the feds. That's a subset of property law that's been carved out. The Supreme Court said that goes to the feds. So if property is the purview of the states and securities are the purview of the feds, what we did is step out and say, hey, utility tokens fall within state jurisdiction. SEC, that's not your jurisdiction. And by the way, it's pretty clear the SEC has been pushed by what Wyoming did, and now we have multiple states, including where we are today, Colorado, having copied that. Montana did as well. I believe Utah is on the way to do it. There's this Rocky Mountain arc of states that's pushing back against the feds on this federal jurisdiction grab. The really important stuff, though, got done earlier this year. And again, I won't go through the list, but let me give you the highlights. The most important thing we did is we defined digital assets as a type of property under Wyoming law. Again, I just went through the high level that the property law is the purview of the states. So what we did was basically say, all right, there's a new type of property out there. It's an intangible type of property called digital assets. We set up three different definitions in it: virtual currencies, which is Bitcoin, Litecoin, et cetera; utility tokens, which we'd already defined in the previous year as something distinct, separate and distinct from securities because they're tokens that have primarily a consumptive purpose; and then digital securities, which are, of course, acknowledged to be securities and therefore subject to federal jurisdiction for securities regulations, but they are property for state law purposes. That's really, really, really important because no other state's done that yet. And we actually ended up in a fight, unintentionally, with a nationalist organization called the Uniform Law Commission that tries to keep states' laws uniform. And it turns out that there had been a very interesting history of how the Uniform Law Commission was looking at regulating this industry. They put out a proposed state law called the Uniform Virtual Currency Business Regulation Act that Coin Center and others had been working on in 2017 to try to counter the bit license in New York. And it hasn't stood the test of time very well, and thank goodness no state has enacted it at all. But something curious happened. The Uniform Law Commission, without reopening the whole discussion, added an addendum, a supplemental part to that proposed state law for all the states to, once a uniform law gets proposed, the idea is that every state will enact it, uniformly. And oftentimes that happens, right? We want to try to keep commercial law as consistent from state to state as possible without federalizing it, and that's how the Uniform Law Commission works. But something curious happened. They created this supplemental act for how to define property in this industry and how to create what's called a security interest against it. And that is, if you lend your coin, how do you ensure that that's an enforceable contract if there's ever a dispute, and that the lien on your coin is actually legally recognized? Now, a lot of folks are going to be scratching their heads and saying, how the hell is this coin lending thing actually going to work? How can you ever enforce a lien on Bitcoin, right? Because you cannot record that lien at the base layer of the technology, at the protocol layer. There's no way in Bitcoin Core to flag that Bitcoin is subject to a lien. So a lot of folks were thinking that there wouldn't be a coin lending market that would evolve precisely because there was no way to record the liens at that level. But in fact, as you all know, there's been the coin lending market in the last 18 months has just taken off. And so how do you actually ensure that this is legally enforceable? And how also do you know if you're buying a Bitcoin that that wasn't subject to a lien that a judge might come back and try to enforce against you? So these sound like esoteric questions, but they're actually very real. I'm not aware that there has been an attempt yet for a judge to enforce a lien against a Bitcoin. And so, you know, a lot of developers probably are scratching their heads thinking, these lawyers are off thinking these you know, esoteric examples that are edge cases and not likely to happen. But I guarantee that at some point they will. And unless and until we get clarity on how you actually can create an enforceable lien on these assets, what's going to happen is that people are just going to go off in all kinds of different directions, and there is going to be a messy litigation at some point down the road. So what Wyoming did was said, here's a way to do it. I'll get to that in a second, but the Uniform Law Commission, coming back to the original story, they created this supplement without even consulting with Coin Center. Peter Van Valkenburg told me they weren't even notified that this was coming. So what they did was give the securities industry control over digital assets for commercial purposes. Some of you are attorneys. The way securities are handled under state commercial law is something called Article 8 of the Uniform Commercial Code. And Article 8 basically says you can have certificated stock, shares, or certificated securities. It doesn't have to be equities, it can be a bond. Certificated, uncertificated, or indirect ownership. Now, the history of this, that indirect ownership bucket is actually how most of us own securities in our IRAs and brokerage accounts. Unless you own the physical piece of paper, that's almost certainly what you own, is, especially for publicly traded securities. You own an indirect share. Now, what it is it's an IOU. Basically, you don't own, you've probably heard Patrick Byrne ask the question at conferences. Do you own, how many of us own stock, right? A lot of people in the room will raise their hands. And in fact, actually, the truth is that what we own in our brokerage accounts isn't stock, it's an IOU. It's just like what we own in our bank account. It's an IOU. We think we own the deposits in our bank account. Legally, we don't. We've lent our money to the bank. We think we own the stocks in our IRA or brokerage account. Legally, we don't. We've lent it to the securities firm. And by the way, they have the ability legally under state law to issue more of those than actually exist. Again, this is why nobody went to jail during the financial crisis. This stuff was actually legal. And so now, bringing it back to the Uniform Law Commission and this supplemental act, they said that all virtual currencies and digital assets get shoved into that regime, where you literally have a security entitlement from a securities intermediary. Who do you think did that? The securities industry would love to get control of this industry, right? And force all of us into using intermediaries for these assets. And so Wyoming looked at that and said, hell no, that makes zero sense. These are assets that are bearer assets, and we should recognize them as such under Wyoming law. So we went in our own direction, and then the Uniform Law Commission came after us. And said, they actually did something very unusual. They actually demanded that the Wyoming legislature withdraw the bill in the middle of the legislative session. Well, I started today with a little bit of disclosure about the culture of Wyoming. How do you think the Wyoming legislators took that? It actually emboldened the legislators to enact the bill that we were passing, and especially once I sat down and walked everybody through it, they understood exactly what was going on. This was sort of an attack, if you will, by the incumbents on a state that was actually doing the right thing and saying, these are bearer assets. We're going to recognize the property rights under Wyoming law for folks who own them directly as opposed to forcing them into this indirect ownership regime. Now, what's the impact of that for you? It means that if you are what's called I forget how it's phrased under the UCC, but essentially a good faith purchaser. If you didn't know that Bitcoin was already subject to another lien, you take it free and control of that lien. That's the way cash works under the Uniform Commercial Code. If you're a good faith purchaser and you didn't know and you weren't defrauding the rightful owner of that cash, then it's their problem that somehow you ended up with that cash. We also have a lien cleansing provision, which is that if your assets are located in Wyoming, let me come back to that because that's going to sound very weird to the developers. How do you locate a digital asset in Wyoming? But if they are located in Wyoming, then for 2 years, then all prior liens are invalid. And then the reason why we picked 2 years is that's the period, the statute of limitations under the Federal Bankruptcy Code for fraudulent conveyance. So if that hasn't been fraudulently conveyed, after 2 years, the liens are cleansed. So you have a real reason to locate your coins in Wyoming. Now, how do you do that? We defined locating in Wyoming as the following. They can either be physically located there. There are a lot of people who've taken old abandoned missile silos, which are all around Wyoming, and turned them into cold storage facilities. You can have your ledger and treasurer and keep keys there. You can be a Wyoming resident. You can be a Wyoming person, which includes a business entity under the law. It's a weird definition, but person can be a human being plus a business entity. So one of the things, and I know Pamela's talked about how you do estate planning for your coins. One of the things that some people do is actually own all their own coins through a Wyoming LLC, and you get the benefit of the laws that way. And then another way is to actually store your coins in a Wyoming custodian. Now, there is no such thing as a Wyoming custodian now, because the law allows custodians to apply for a Wyoming special purpose depository institution license as of October 1st. I'm going to get to that a little bit in a little bit more depth in a moment. But hopefully what you get if you're a developer, and this all sounds a little Greek to you, is to realize that there's actually some definition around the law here. I'm sure we didn't get it perfect, but nobody's uncovered major problems with it yet. We're going to be doing some technical corrections to the laws in the next legislative session, but so far, nobody said this is unworkable. A lot of folks have actually said there's something special here, and having that legal definition is really important. So I went deep on literally 2 of the bills, which is HB 62, classifying digital assets as a new type of personal property under Wyoming law, and SF 125, defining property rights for digital assets and creating the digital asset custody regulatory regime. We did a couple of other things that are important. At the very top, Wyoming has a FinTech sandbox, which essentially says, if you're going to run afoul of existing regulations, you can apply to do that. And you can get a grant from the regulator for 2 years with an extension for an additional 3rd year. And by the way, it's reciprocal with other sandboxes, including the UK and Bermuda and Arizona and other states that are putting FinTech sandboxes in. So it's a way for you to actually say, all right, I'm not going to comply with existing regulations. You just have to apply. You have to go to the regulator, post a bond, and do it, and then just stay in touch with the regulator. So that's a pretty powerful concept right there. All the consumer protection laws still apply, but what it means is if there's some crazy law that's in your way, that's a vestige of history, you now have a way to get around it. And you just have to stay in touch with the regulator and make sure you're not breaking the basic, fraud and theft and consumer protection laws. We also created HB 113, special electric utility agreements with cryptocurrency miners. We got some pretty big cryptocurrency miners coming into Wyoming. It's an energy-rich state, and the coal industry in Wyoming is basically, because of what's happened with coal globally, it's really on its knees. Some of the biggest employers in Wyoming recently declared bankruptcy and shut down some of the mines. It's a very sad story for the people affected by it. And what we did was actually enable both the electric utilities to negotiate special utility agreements outside of the traditional rate-making process, but we also allowed the big miners, this would be, of course, not the hobbyists, this would be the big ones, to come in and actually buy the power plants and literally set up cryptocurrency mines. You've heard all the stories, even in Colorado, about people being angry about cryptocurrency mines popping up in their state. Wyoming saying, come on in, and doing everything we can to bring them in. So let me then talk next about this enhanced digital asset custody regime. I've alluded to it a little bit. You have to be a licensed financial institution. Again, this is, how is it that somebody who's critical of the financial industry is working on creating a new type of financial institution? I'm helping to ensure that a bridge is being built between these two financial services industries. The traditional one, which has all kinds of structural problems, and the new one that we're all working in, which doesn't have those basic unfairness structural problems. We worked with the SEC pretty extensively and addressed the two issues, the lack of clarity of legal status of digital assets in bankruptcy. This is one of the pretty basic issues, if you think about it, that before the SEC and the powers that be in Washington are going to let big financial institutions get involved with crypto, they want to know what the legal status is. I just spent 10 minutes going through that. So we now, every judge in Wyoming, or every judge who's applying Wyoming law, more specifically, has a roadmap to understand exactly how those assets are going to be treated under the Uniform Commercial Code and in bankruptcy and any contractual disputes. The SEC has a preference for banks and broker-dealers over trust companies due to the clarity of the wind-up rules. So that ties back up to the previous bullet point, which is what happens if a financial institution goes bankrupt and they've got all these assets that have unclear legal status. We've got clarity of the legal status now. It turns out the SEC, for those of you who are interested in custody, gave some guidance in July, as you may have read, and you may have seen me talk about footnote 13. Footnote 13, the SEC buried something in their guidance, but it was really important, where they said that a bank has a safe harbor for good control location under the custody rule. Now, the interesting thing is, how many banks do you know that are actually involved with crypto? Some are lending fiat, right? But no regulated bank in the United States is directly involved with crypto. It's not allowed under the FDIC or OCC rules. So therefore, Silvergate and the like are obviously actively involved in banking the industry for fiat purposes, but they're not actually taking any Bitcoin onto their balance sheet. So here's the thing. The FDIC is not allowing banks to get involved even for crypto custody, right? Even off balance sheet for custody, just providing custody services, much less putting on balance sheet in actually taking in a deposit. So if the banks are not being allowed to get into this industry, and the SEC is saying that a bank has a safe harbor, not a trust company, has a safe harbor for crypto custody, what does that mean? It basically means that under the existing regime, there isn't a way for this industry to come in and get good control location for digital securities. So they've kind of created a perfect block, if you will, of this industry. Except this rogue state called Wyoming set up a digital asset custody regime that authorizes banks to custody digital assets. So there's one and only one bank, one type of bank in the United States that actually qualifies for that good control location safe harbor under the SEC's rules. The third from the bottom is really important. I alluded to this earlier. The custody of these Wyoming digital asset custodians have to offer custody under a bailment. What's a bailment? It's like valet parking for your car or a coat check or something like that. When you valet park your car, you're not giving them title to your car, you're just giving them temporary possession, and you're not allowing them to do anything with it but park it in the garage. That's a bailment, legally. You still have title, you still have dominion and control, you've just given up possession, and temporarily given up possession, and the garage is not allowed to do anything other than what you've expressly directed it to do. That's exactly how digital asset custodians in Wyoming work. That is not how securities custodians work today. When you hand over your brokerage, as I talked about earlier, your brokerage assets are sitting in a broker-dealer. If you hand over a physical share of Disney stock that your grandparents gave you, and you give it to Schwab, and they turn it into an electronic share, that's going to be custodied at a custodian. And that custodian, they're in an IOU relationship with Schwab, who's in an IOU relationship with you. They're all subject to that indirect ownership regime that I talked about earlier, which allows them to create more securities than actually exist. And they're off lending it and doing all kinds of things without your permission and without your knowledge and without paying you. I discovered that during running the pension business at Morgan Stanley, where we actually had a type of custody account for securities for a pension fund that did not allow the custodian to lend the securities. They were about to be delivered the next day to close a transaction, and the custodian called and said, "We don't have 15 of the securities on this list." It wasn't one, it was 15. And the chief investment officer said, "How is it possible that you don't have them? They're on my screen, they're in my account." And the custodian said, well, yeah, I know that. We owe them to you, but we don't have them. That is actually a felony under Wyoming law. So not only did we set up custody under bailment, where it's just like valet parking, your financial institution is merely a service provider. They're not a counterparty relationship with you. They're just a service provider. You have legal title to that asset. You can choose to own it in a fungible form. So for staking coins, right, you want to give it, you want it to be in a fungible form so you can actually increase your staking gains. You can own it in a non-fungible form, or you can own it, you can choose to own it in the omnibus account where you have that indirect ownership regime if you want to go and lend your coins and the like. But the critical point is under Wyoming law, that's your choice. The individual who's depositing assets in a Wyoming custodian is the one who chooses the form of custody. That simply doesn't exist in securities today. This is a powerful concept, and I'm 100% confident New York's going to be coming after us when they figure out what this really means. But as a result, it means that you have significant investor protections. I mentioned that there is not under Wyoming law, if you sell something you don't own, it's a felony. There's a great Supreme Court case where somebody actually tried, he had an industrial diamond, and he pledged it as collateral for a loan, and then without telling another bank, he pledged the same asset as collateral for a different loan, and literally that was felony fraud. It's great case law precedent. I would love to be in a regulatory position someday to be going after Wall Street for doing that, because it literally is a felony under Wyoming law. But the good news is that the better path, of course, is doing what we're all doing, which is just building a whole new financial system and making it fair. Those digital asset custody rules are going to be released this week, and they have some very interesting aspects. One is, for the first time, we'll actually have a definition of fork. Under regulatory rules. What happens under a fork? And we had some of the best people in the industry, including Michael Perklin. We had the whole tech team from Kraken. We had Kingdom Trust. We actually had Silvergate Bank. We had a lot of people helping us out, and I'm pretty sure we got it right because we took months to get this right. And the fork policy, I think you guys are all going to agree with. First of all, under the rules for these custodians, they have to clearly define what the asset is by making reference to the source code itself. So in the contract, I know of a big institution today who says Bitcoin is in the contract. They define Bitcoin as a digital asset. Okay, so if Bitcoin forks, guess what? They have total control over what they define Bitcoin is. So under a Wyoming digital asset custodian, if you're going to be in this business, you actually have to define what version of the source code and make reference to the GitHub in your contract. Then, if that coin forks, there are 3 different scenarios. One of which is if they change the consensus rules from what was in your contract, making reference to that original source code version, then if the custodian is not going to support the new coin, so if there's a change in consensus rules, or sorry, if they're not going to support the old coin, so this would be sort of like if a custodian decided in the ETH Classic fork that they were not going to continue to support ETH Classic. Well, your original contract with them is for ETH Classic, right? That's the consensus rules that you contracted to deposit your coin there. If they're no longer going to support it, then they have to give you the ability to, they have to get consent from you, and they have to give you your coins back if you want them. If they are going to support both, they just have to notify you, and if it's just a soft fork, they still have to notify you. All this this was months, as you probably imagine. The devil's going to be in the details. I think this is going to be out this week, but I think that the disclosure and the fork policy definitions are going to be received very well because I'm not a developer. I know where the limits of my abilities are. I went to developers who really basically argued out this rule. What's the right rule for how to handle forks? And oh, by the way, your custodian is prohibited by Wyoming law from benefiting from those forks if you don't give them the ability to share in those gains with you. So again, I think we got this right. And what you're going to see is the financial institutions that come into Wyoming have no problem complying with any of this. This is all the basic fairness stuff that we would all agree is clarity of property rights. This is respecting the ethos of the industry. If we're going to have to set up a third-party institution, let's do it this way. And so again, this is mostly for institutional investors. I'm sure some people will offer these services to retail, but this is, I think, what's going to get the vanguards of the world to start offering mutual funds and ETFs and the like. There's going to be a hardcore custody regime that's investor friendly in Wyoming. Lastly, let me close with this special purpose depository institution. This is the killer app. It's what I alluded to earlier, footnote 13. You gotta be a bank in order to get the safe harbor for good control location under the custody rule. And this is also this is also going to supersede for people who have the Wyoming bank law, bank charter. This is going to supersede the BIT license in New York. Nobody's actually done that yet because, of course, it doesn't exist. But there's great case law and great statutory law in New York that if you have another state, if you have a state chartered bank from another state, that is recognized in 42 states. So New York is not one of the 42 states, but in New York, you are allowed to, with the approval of the New York Department of Financial Services, open a branch. Now, so you still have to go kiss the ring in New York, but basically, this license is superior in the hierarchy of financial institution licenses. The bottom of that hierarchy is money transmitter, then it goes trust company, then it goes bank, state chartered bank, and then it goes national bank probably, and broker-dealers are sort of off to the side. But in deposit-taking institutions, that's the hierarchy. You want a bank, not a trust company. The BIT license is somewhere around between money transmitter and trust company, just to give you some background. So if you've got a bank license from another state, that trumps that BIT license. And so I think what's going to happen is a lot of the folks that have New York trust licenses are going to end up pivoting into Wyoming. They, keep the New York trust licenses until you get your Wyoming one. But this one is this is a killer app. It is, for those of you who are Austrians like me, it is a bank that cannot lend. It's a 100% reserved required bank, and it is not authorized to make loans. That's really important because in the middle there I say it's not a bank under the Bank Holding Company Act. We threaded some really important needles here. It's a bank when it needs to be, and it is not a bank when it doesn't want to be. So this is very, very, very cool, and it is able to act as a digital asset custodian pursuant to its trust powers. So let me explain what's going to happen. This is, I think, a pretty important, October 1st is a pretty important date for the industry because exchanges, digital asset exchanges, are not required to be licensed in Wyoming. This bank, of course, is a bank license, so it's going to take 6 to 9 months for everybody after October 1st to get their license. That's why I'm talking about this time next year, the doors are going to be open. But what's going to happen is that I think a lot of the exchanges are going to come into Wyoming because of all those digital asset laws that I talked about, defining property and giving clarity as to the rights and obligations of parties in this industry from a backwards compatibility of a law perspective that respects how the technology actually works. And so I think exchanges are coming into Wyoming, and I think a lot of what will happen is an exchange will get set up with a sister special purpose depository institution, and so you will actually be having this industry with its own banks, with its own Fed master accounts. Now, they're going to have to still comply with all the Know Your Customer and anti-money laundering rules. Those are federal laws. As a lot of you have seen, I don't like those laws. I think they're unconstitutional, but they are the law of the land, and so these institutions have to comply with them. There's no way around that. I wish I could have figured out a way around that. But what we did is basically create a means by which this industry no longer has to be dependent on third-party banks. You can control your own destiny if you want to, because you have a direct relationship with the Fed. The Kansas City Fed has been very active with us behind the scenes. The governor of Wyoming actually used to be on the board of the Kansas City Fed, and he helped the current Kansas City Fed president get her job. So there's a nice personal relationship with them. And what we've been told is that Washington is looking at what Wyoming is doing here as sort of the proving ground. And they're going to watch Wyoming for a couple years, and then you'll probably start to see them loosen up the banking regulations maybe 3 to 5 years down the line. But the only place where you're going to be able to have this kind of financial institution that checks all those boxes is in the state of Wyoming. Do not be surprised on what's coming down the pike in the next several months in terms of announcements of pretty major players in this industry coming into Wyoming. Let me stop there. We have about 12 minutes left. I want to make sure, I'm looking at Pamela to make sure we get our 50 minutes in. Let's fire away with questions. Please dig in. Yes?
You said the Uniform Law Commission did this addendum. They didn't know about it, but they did it. Who were they?
Yeah, the question is, who's the Uniform Law Commission that created that supplemental act without going back to that whole group that helped advise them on the original Uniform Regulation of Virtual Currency Businesses Act? Who is they? It's an interesting question. There were no, to my knowledge, there were no crypto industry people involved. Not even Coin Center was involved in that. The they is every state has 3 Uniform Law Commission commissioners. It tends to be law professors and retired attorneys, right? So there's definitely a generational difference, shall we say, because it's a time sink, right? So actively practicing attorneys don't tend to volunteer for a lot of work on things like that. Oh yes, you can find a list of names and draftees on the Uniform Law Commission's website. But to their credit, what happened was they knew they overreached when they demanded that Wyoming withdraw this bill. And I think they knew it backfired on them too. They've now pulled the whole thing back and said, and by the way, no state enacted any of those laws. And thank God there are all of you in this industry who are watching. Nevada actually came the closest, believe it or not, to enacting it. And because it had one of the people who's a law professor at the University of Nevada, Las Vegas, who was one of the drafters, and he's very well respected, and he's taught a lot of the Nevada lawyers who went through his law school, and he came up and testified for it, and this industry came out hard at a grassroots level and said, this is nuts, these are bearer assets, why are you forcing us to put these into third parties in order to get legal recognition? And they got it defeated. So this industry has just been awesome. Our little small ragtag army of people who are volunteers, in a lot of cases, it's people like me who are not developers, and the way we can give back is to make damn sure the legal regime doesn't get in our way and try to tear it down when we can. And that's what happened. And so they got it torn down in Nevada. To their credit, they've now reopened the whole thing. And they recognize the Uniform Commercial Code was created in the 1950s when there was no such thing as intangible assets. Back then, we didn't even recognize intellectual property as an intangible asset under the law. So now we have software licenses, now we have identity, now we have intellectual property, we have air rights in real estate, all these things that are intangible. And how does the law deal with them? The answer is not well. And so they're now reopening the whole thing, and in about a month, I believe, here in Denver, the Uniform Law Commission is meeting again to reopen the whole thing. And they actually have invited Wyoming to come, to their credit. I think all the sort of histrionics calmed down, and they now realize, I think, that they screwed up. But it's a very interesting question, who was it? I asked a rhetorical question, was it the securities industry? Because it's pretty clear the securities industry was the primary beneficiary from what the Uniform Law Commission proposed. And they would, as you guys all know, love to find ways to block the development of this industry. But we figured out a way around it. And to the Uniform Law Commission's credit, I think they realized that they didn't get it right the first time. We're going to help them get it right the next time. Yes, sir?
Question about, you said the reciprocity nature between the sandboxes.
Mm-hmm.
How does that work? Does that require additional registration? I mean, how does that actually work?
Yes, the question is reciprocity on the sandboxes. How does it work? Does it require registration? Yeah, unfortunately, it does require registering with the regulators in each of those regimes. But it's not an onerous process, to my knowledge. It's literally just letting the regulator know who you are, where's your address. There may be a bond that has to be posted, and that depends on what your business is. So in some cases, it's as small as $5,000. It's not onerous. It's designed to help innovators, but designed to make sure the regulators know how to reach you if you're doing something that breaks other laws, like the fraud laws, et cetera. Yeah, so I think it is unfortunately like money transmitter, where you're probably going to have to go state by state and notify, but it's not an onerous licensing regime. I saw a hand up over here. Yes, sir. Examples of entities that have already migrated to Wyoming. Probably the most prominent is IOHK. Charles Hoskinson's commercial venture literally redomiciled from Hong Kong to Wyoming. They didn't change. It used to be input-output Hong Kong, and I teased them they should be input-output IOYO instead of IOHK, but they're not going to change their name. I guess probably the most prominent one that's knocking on the door, I'm not revealing anything that's confidential here, is Kraken. By the way, we have the Wyoming Blockchain Stampede is September 19th through the 22nd. The hackathon is the 20th through the 22nd, so it's the third weekend of September in Wyoming. Kraken is the lead sponsor. All the companies that are showing up in and around that are kicking the tires on Wyoming, shall we say, including IOHK is also one of the big sponsors. You're going to see a big Kraken team come because we're doing the task force meeting on September 19th and 20th. So yeah, stay tuned. Yeah. Yes?
What is the relation between your money transmitter laws and kind of your taxonomy defining utility tokens and digital assets? Like, did you figure out, oh, we need to tackle money transmitter laws first, and that's when you kind of went into defining, all right, like a utility token, digital
Yeah.
asset, you don't need a money transmitter for that, or how did you guys work around that?
So the question is, how does the money transmitter law work with the token taxonomy in Wyoming? And the history is the original money transmitter law required, but before I got involved, this is why I got involved, by the way. I was donating appreciated Bitcoin to the University of Wyoming and discovered they couldn't take it because the money transmitter law prohibited it. It didn't prohibit it technically. What it did was it required that the money transmitters in Wyoming have to hold a dollar-for-dollar reserve in addition to the asset itself, which of course made it uneconomic because they would have had to basically be 200% reserved, which made no sense, right? So the Coinbases and Circles of the world pulled out of Wyoming in 2015, and that's what got my whole involvement going. I was like, guys, we got to fix this. And then the snowball picked up snow as it rolled downhill, proverbially, and we did all this. So what we did when we fixed it, it was the first law actually that I don't know if I can go backwards. Yeah, I can. Exempts virtual currency transactions from Wyoming's money transmitter law. Basically, the whole virtual currency that whole grouping is exempt from the money transmitter law. So digital securities are, of course, still subject to securities law, and then utility tokens have their own regime. They're also exempt from money transmitter. So basically, in this industry, almost certainly you don't need a money transmitter law unless you are also dealing in fiat. So Coinbase ended up needing to get a money transmitter license in the end because they actually offer fiat on and off ramps. But if all you're doing is dealing in virtual currencies, then under Wyoming's regime, you don't need a money transmitter license. That's the way it works. Yes?
Can you talk a little bit about HB 126? Because
Yes.
I'm thinking about, is that allowing basically token holders to be members of an LLC and sort of paving the way for DAOs? Is that the purpose behind it?
Yeah, great question. To repeat for those listening in remotely, HB 126 authorizes series LLCs. And the question is, does this allow token holders to be members of a series and potentially lead to DAOs? That is exactly one of the applications of series LLCs. The history of a series LLC is basically you've got a parent and you've got children. Almost all of the open source software foundations are set up as series LLCs. I believe Linux Foundation is set up that way because they want to ring fence the liability of all of the applications of the code, which is owned by the foundation, which is the parent, and that's where usually the MIT license is. And then everybody who's using it sets up a child LLC off that parent. It's also heavily used in real estate, but we knew it would be used in this industry as well. And there are people who have looked at actually setting up their project as a series LLC and having each of the individual members have their own series LLC hanging off the parent. I'm not aware of anybody who's done that yet, but again, I'm not a gatekeeper, and Wyoming doesn't keep that information, so it very possibly could have been done, and I just don't know about it. The question as it relates to DAOs, we are talking about that in our task force now, because we've had a lot of people come to us and say, why do you need human beings to be involved in these organizations? Why can't we create a DAO that's recognized under the law? And we looked at that and said, actually, I think the better way to go is to remove criminal liability for the developers who contribute to such projects. It actually is a broader application, a broader protection, because a DAO, by definition, will be open source and will have developers contributing to it. And so if the only people involved with a DAO are the developers who write the code and contribute to the code, then if we take the liability for those developers off, we don't need to do anything else. So that's the direction we're going. Now, the Series LLCs, you have a human being. There has to be a human being involved with all those business entity forms right now. A corporation, an LLC, a limited partnership, statutory foundation. There are a whole bunch of different versions. A Series LLC does have to have a member. It has to have an organizer, so there has to be a human being involved with it. So, yeah, but it could be a foundation, absolutely. I think in a way, it's kind of like the way the Swiss foundations work, that so many of these projects got set up under, including Facebook Libra. They all went to Switzerland and set up Swiss foundations to own the open source code. But they didn't set them up as Series LLCs. This just gives a ring fencing of liability for those who actually create applications. I'm looking at Pamela. Do we have time for one more question? One more.
What about the definitions, the new legal definitions of forks, self-fork, and unself-fork?
Question about the new legal definitions of forks. That is actually going to be published. The rules should be finalized as soon as literally tomorrow. So you'll see, I'll probably write a Forbes.com piece about it. And it's pretty detailed, but what it turns on is, first you have to have, if you're a digital asset custodian in Wyoming, that you have to have a contract with your customer that clearly defines the source code by reference to its GitHub code version. And so once you've clearly defined the source code for the asset, so that's the asset that you're custodying is something that's subject to that source code. Anytime you have a material change to the source code, that's when it triggers the three different categories of notice requirement. And there's only one requirement where you actually have to get consent from the customer, and that is where the originally contracted source code is no longer going to be supported by the financial institution. So that's how we made it clear that all these sort of, crazy forks that nobody's supporting, the financial institution doesn't have to support that fork. That's how we prevent spam, basically. They just have to, if the source code, if the consensus mechanism in the source code changes, that's when they have to go, and they're no longer going to support the original. They're breaking their original contract if they don't do that, and we're allowing them to break the contract, but they have to go get the consent of the customer to do that. Otherwise, they have to give the asset back to the customer. All right, thank you guys, great questions.